violate these commandments.
In the summer of 1974, I heard one of the greatest lectures on trial practice I've ever heard anywhere. The lecture was delivered from the top of a mountain overlooking Boulder, Colorado, during the course of the National Institute for Trial Advocacy. The speaker, Professor Irving Younger, his subject, the art of cross-examination. I'm Bob Hanley, and I'm chairman of the section of litigation of the American Bar Association. When I heard that lecture on the top of that mountain, I knew that somehow I had to get it to you, the American trial lawyer. We talked Irv off the mountain and onto the podium at Montreal, where he delivered his reprise of his Sermon on the Mount. Happily, you're going to be able to hear it very soon. Irv Younger is an outstanding trial lawyer. He's a former district attorney in New York. He served as a state court trial judge. He was on the faculty at New York University School of Law. And today he holds the Samuel S. Leibowitz Professorship in Trial Practice at Cornell University. Irv expends unbelievable amounts of time and energy trying to make better trial lawyers out of all of us. This section of litigation is very proud and very happy to be able to present to you Professor Irving Younger on the art of cross-examination.
Why then do I dare to stand before you and sully so beautiful an evening? I think there is some profit in talking about cross-examination, ladies and gentlemen, in this sense. No, I can't, and I don't think anybody can, help you to be a good cross-examiner. But I think that I can help you to avoid being an abominable cross-examiner. And that modest objective is my objective this evening. Let me begin by suggesting to you an approach to cross-examination.
Over the years, I have come up with a set of suggestions, guidelines, if you will, which, if made part of your intellectual repertory and made to become second nature, will guarantee, and I am choosing my word carefully, will guarantee that every cross-examination you conduct is reasonably competent. It will not be a flash of lightning. No, it's not going to be Clarence Darrow. No, but you will never humiliate yourself. You will never throw the case away on cross-examination. So desperate am I that everybody achieve that really minimum level of professional competence that I withdraw here and now my designation of these things as guidelines or suggestions. They are not guidelines or suggestions, they are commandments in the sense that you must follow them. If you do not, if you violate them, you will pay the price. And you all know how many there are because they're listed in the outline. There are 10 of them. But because we've been together all day and start to be friends, I wish to make a confession. There really aren't 10. There are only 6 or 7. But I say some of them in different words to make it add up to 10. Because 10 Commandments has a literary ring that I find appealing. If you will cross-examine in accordance with these suggestions, I can virtually guarantee, not that you're going to be a brilliant cross-examiner, but that you won't be ashamed of yourself. You won't be a buffoon in that courtroom. Because I am so anxious that each of you be at least a reasonably effective cross-examiner, I withdraw my designation of these suggestions as suggestions. Instead, they are commandments. First commandment, be brief. That's it. Short, succinct. Remember, cross-examination, unless you are Clarence Darrow, unless you are Max Stoyer, cross-examination for the rest of us, however, is a commando raid. It's not the invasion of Normandy. In, out, that's the whole idea. Right? So you will be brief. Second commandment. Short questions, plain words. Again, you've got to acquire the knack of asking short questions using plain words because in law school, by and large, you have been practicing writing long sentences and using elaborate words, lawyerese. I don't know why it is that it is a custom among lawyers to speak and write this peculiar dialect of English that is known to nobody else except lawyers. So you use short questions, Plain words. Third commandment. On cross-examination, you will never, never, never ask anything but a leading question. You put words in the witness's mouth. That's the whole idea on cross-examination. That's how you control the witness. That's how you make it go where you want it to go. How often have I been sitting there in court when a lawyer on cross-examination stands up and says to a witness, "What happened next?" "Oh, no,